Good morning, everyone. Just one more comment in addition to what John said. I will actually be covering more than just the FLSP. It's essentially a year in review with respect to family law. For those who do not know me, my name is Misheal. I am the Family Law Committee Chair with Fola. Uh, the information that I'll be providing you this morning, it will be broken into three parts. Just as a housekeeping matter, I ask if you have any questions to please post them below in the chat, and I'm happy to answer any questions at the end of my report if possible. Just by way of intro, it's no surprise that many of us continues to hear that family law remains to be in a state of transition. It's evolving, specifically in post-COVID as well. And we've all, or some of you may have heard about the recent amendments that was made to the Divorce Act and the recent introduction of Bill 207 by the Attorney General that is moving Ontario Family Law Act, Forward Act, pardon me. And lastly, what may, or some of you may have indicated, the most controversial issue surrounding the Family Law Service Provider license or scope of practice. I'll just briefly touch on the Divorce Act. The amendments that was made to the Divorce Act under Bill C-78 was scheduled to come into effect on July the 1st of 2020, but due to COVID, it has been postponed. And my understanding, it will come into effect hopefully March 1st, 2021. In essence, the amendments mainly deal with the use of a new terminology of decision-making and parenting time rather than the old terminology used, custody and access. It also addressed the mobility issues and the definition of best interest of the children. That's in essence the Divorce Act. The recent involvement that we've had, Fola had, is with respect to Bill 207, moving Ontario Family Law Forward Act, is that we were invited to make submissions, and we've done so early in the year on January the 15th, in response to the Attorney General's request for feedback on Bill C-78. I could indicate what we have in essence indicated is that they should largely incorporate incorporate what was under the Divorce Act into the into the Children's Law Reform Act in Ontario, in order to protect and provide guiding path with respect to families who are affected by separation. Also, subsequently, we were invited, and specifically October 13, I participated on behalf of FOLA before the Standing Committee on Justice Policy, and we've made submissions. And in short, these submissions were as follow: that we've agreed that the proposed Moving Ontario Family Act help in providing continued effort and in making access to justice more accessible to Ontarians, that it simplifies the appeal process. Before, there was some uncertainties as with respect to the appeal. Now they simplified it, and it addressed the archaic language concerning the Children's Law Reform Act. It also addresses some of the concern issue with respect to child support. It assists families, and that the proposed create fewer inconsistencies between the federal and the provincial law, and by adopting the same terminology across the board rather than using different terminology between the between federal and provincial legislation. The new terminology also is a welcome step, and it's certainly away from the adversarial approach that we've seen in the past few decades, and it's towards a child approach center rather than, frankly, what I put it is, I summarized it as parents in an Olympic, they wanted to see who would finish first on the podium, and it certainly promotes cooperative problem solving. The expansion of the best interest of the child test, what was proposed in the legislation, it provides the court, lawyers, and litigants essentially with a primary consideration and factors to be taken into account. So rather than, I don't want to say on a whim, but it provides a guiding path essentially and makes things much easier. Also, Fola, subsequent to our submission to the committee on October the 13th, one of the MPPs posed a question, and unfortunately I wasn't aware of one of the articles that they posed a question on. I subsequently looked at the article and I sent them an email, and I sent also the AG's office, I copied him on that email, is with respect to the child protection cases. Originally, what the AG's office has indicated is that they've made, again, the appeal process is that you're required a leave to appeal. What we propose is that any application that is made pursuant to the Child, Youth, and Family Services Act should have the right to appeal straight to the Court of Appeal without a leave. And that was heard, and the AG's office has made the amendments to reflect that. Now, the amendments was made not just by Fola, by other stakeholders as well. I could indicate currently the Bill 207 is on a third reading. So it's going forward, and hopefully it could be implemented at the same time as, or come into effect at the same time as the Divorce Act next year. Now, I have saved the best for last, and it's to do with the FLSP. I'm sure there is no doubt that this has been an interesting topic. I could indicate that we've done, I've spoken to many lawyers from across the province. And I was quite pleased by the turnout and the lawyers that have taken time out of their busy day to participate and share their thoughts with me, and share their thoughts with other members as well. I've also had discussions with many stakeholders across the province. I could indicate, for example, I've spoken to the Toronto Law Association, the Advocate Society, the Family Dispute Resolution of Ontario, OBA, Family Law Association, and many other stakeholders. And also we've conducted jointly, that's Fola, the Advocate Society, and the Toronto Law Association. There's a survey out there. Approximately this far, we have about 240 people completed the survey, and we're hoping for more participants. So I would, and obviously the more participants, the more data that we could capture, and it would be an integral part of our response with respect to the FLSP. Katie will be sending out an email tomorrow, and I'm going to be asking with a link, and I'm going to ask all the presidents if they could encourage their members. It's going to be going to the librarians, and asking the librarians to send it out. I would encourage every single president to let their members know of the survey, and if they could take 5 to 7 minutes of their busy time to complete it, it would be quite helpful. Now I'll just turn my attention to the FLSP, and in summary, what essentially I have this far. Again, this is a draft. I expect to complete my my complete response in the next week or so. Just to give you some background, and I hate to repeat this if some of you have heard this before. This is the genesis of this is started by then the Attorney General Yasser Naqvi. It's in relation to the some of the litigants of the idea, the perception that they were grossly underserved in Ontario, and it caused a great deal of spike in self-reps individuals that are before the courts. Jointly, the AG and the Law Society of Ontario in 2016 have asked Justice Brancalo to undertake a consultation that would see the possibility of expanding the legal services option for families of Ontario. And obviously they include the proposals of paralegals, amongst others, such as law students or law clerks. On December the 31st of 2016, after receiving submissions from various organizations, including Fola, the Brancalo report was released, and the report has made 21 recommendations. I'm not going to go into the recommendations. The report is lengthy. It's readily available on the internet through Fola's website. So if you want to have a browse of the recommendations, feel free to do so. So in response to the Brancalo report, the Law Society On December 1st, 2017, I believe, convocation, they've determined to create a specialized license for non-lawyers to provide services in the area of family law. In July of this year, fast forward 2 years, the Law Society has invited us, amongst many stakeholders, pardon me, across the province. They were invited to make submissions with respect to the FLSP. I could indicate that a lot of time was invested in this, and Fola is determined to put a response that captures the voices of all lawyers across the province. In essence, and in short, again, I want to emphasize that the report is not 100% completed. In essence, what we have this far is that the scope does not provide and or increase access to affordable, competent legal services. Simply put, allowing paralegals to expand their scope of practice to include family law without any empirical data, that on itself does not equate to affordable access to justice for Ontarians. There is the general impression that legal fees charged by paralegals to clients are lower than fees charged by lawyers for similar services. Fola has conducted a deeper analysis, and it showed that there were some doubts and uncertainties with respect to that, and whether it will make actually any significant cost difference at all. I could indicate, I've mentioned that we've, along with the Advocate Society and the Toronto Lawyers Association, a survey. And I don't want to be giving numbers, but I could tell that based on the survey this far, a lot of, there's about 33% of lawyers currently in Ontario that they charge less than $200 an hour this far, based on that survey. Furthermore, we looked at, there's lack of empirical evidence which to gauge this issue. Lawyers, legal fees continue to be tracked provincially, nationally, but at the same time, there's nothing that been found with respect to paralegals that is regulated in the market. So there is that data that it's not readily available. A number of new initiatives being implemented that would assist individuals seeking counsel in family law matters. And this was actually recognized by our very own treasurer, Teresa Donnelly, and that was recently in October of last week. Oh, sorry, last week or the week before, my apologies, sometime in October. We've also indicated that the FLSP is, well, not indicated, of the view for now, that the FLSP is a de facto family lawyer with about a quarter of the education and training. And there is certainly some concerns with respect to its implementation. We have concerns with respect to the scope of permissible activities, and there are essentially all areas of family law with a very few areas that is being excluded. Quite frankly, and I hate to put it this, it's everything but the kitchen sink. And in any event, having said all of this, we're proposing that the scope would be limited to certain areas. Despite the fact that we disagree, we're of the view that, or majority of the lawyers saying, we're of the view that if they're permitted to have or to practice, their scope of practice should only be with respect to uncontested divorces. The scope of practice should only include custody and access where no expert evidence is needed or required, very similar to what the LSO has proposed in their call for comments, and child support where only in relation to T4 employees. Once is someone self-employed or has shares in a corporation, et cetera, paralegals should not be dealing with this. And certainly we're saying the Change of Name Act. I could indicate it's further, are further considerations that I might include, such as, for example, first appearance courts or consent orders where paralegals could act as an agent. Again, it's not 100% there, but it's an idea and it's a thought that I have in mind and that I will consider in the next couple of days to be included in my final submissions. Otherwise, FOLA could not support the other areas as suggested in the call for comments, such as spousal support, property issues, and we're asking that these plans should be outside the permissible scope. Also, we are or my thinking of also raising, there's also complex eventually issues that could fall from what we portray to be a within scope to out of scope issues. So one has to be careful. And family law lawyers, when you speak to them, they all say there's always some form of other areas of law that is within the issues that comes before the lawyers. So we want to make sure and careful if paralegals are given that scope of practice, it doesn't fall within, outside of that scope. Then, quite frankly, it would be unfair. It would be unjust to litigants now that they have to go from a paralegal to a lawyer. And the idea behind this is access to justice and affordability. I fail to see that. In any event, I'll continue on with respect to competency. This is a very difficult area. Essentially, what is proposed is creating a family law lawyer with 1/4 of the education. They're asked that they from high school to 2 years of college diploma on to becoming a paralegal, where a lawyer, we all know what we need to do to become a lawyer, and I won't get into that. Many of us has done it. With respect to also what we've looked at is there's the limited license legal technician program, an LLLT, that's based out of Washington. Essentially, in another term, it's paralegals having practicing scope of practice falls to family law issues as well. And my understanding that this program has now become the program is sunset because it was not, for all intended purposes, didn't function as it had been projected. So, someone else tried it and it just didn't work. Also, I'll go back to the empirical evidence. This whole entire exercise is predicted on the assumption that FLSP will be less expensive than a lawyer. But then again, there is no evidence to support this. This is a great leap in logic between we need access to justice to FLSP will be the answer. Again, one of the other thoughts that we have is that if the FLSP should be rolled out, it should be done slowly and incrementally rather than let's grant them the following areas that falls within the scope of practice. We've made some recommendations. One of the recommendations, I have to be cautious of the time. One of the recommendations is the family law rules that should be revisited. Family law lawyers would tell you that some of the rules is it's not in the litigants or not in the best interest of the clients. Repetitive court appearances that if it's futile doesn't, it's just extra cost, extra burden, and it does not assist in resolving the matter. One of the other suggestions or recommendations that we are going to make recommendation that there should be an increased funding in Legal Aid Ontario. There has to be some expansion in the technology aspect of this to make it easier for Ontarians to have access to justice. Other initiatives such as the Law Society and the Attorney General's Office to consider supporting and providing some assistance in implementation of the Pro Bono Student Canada and the launch of Family Justice Center across Ontario, the expansion of the legal coaching and unbundling services by family law lawyers, and finally, the alternative dispute resolution. I think this should be the forefront of any initiative driven by the Law Society to promote this amongst the family law bar. It's imperative. I think we all, some of us who has keen on alternative dispute resolution know that this is one of the best ways in resolving and cost-effective matter to many litigants. This is in essence my short synopsis of my report and our involvement. I if anyone has any questions, by all means, I'm happy to answer it. And Sheena, you know, you can't answer any, you can't ask any questions.
I'm just happy to have heard your report, Sam. Thanks for letting me hear.
Thank you, Sheena.
We can chat after.
You're going to hear it in a couple of weeks anyway, so it won't make any difference.
It's great for us to hear about it. Thank you. And I appreciate all of the good work you've done, Sam. From our perspective, you took this seriously, and we really appreciate all the good work and heavy lifting you've done. So thanks very much.
Pleasure. Thank you. Any questions? Does anyone have any questions? Well, you're making my day much easier. All right. Now we're going to move on to the most important part, your 15-minute break. So we'll take a break for 15 minutes. It's 10:36. Should we say 10:50? Everybody should be back, please. Thank you.